Karl Konrad and welcome to the March edition of Australian Immigration News, brought to you by Australian Immigration Law Services. We have had a jam-packed month of immigration law changes, and in a couple of days we'll also be bringing you this special budget edition. Let's get into what's been happening in Australia in the world of immigration. In response to the terrible situation in Ukraine, the government has provided support for Ukrainians leaving the conflict zones. A special visa will allow people to live and work in Australia and access Medicare and the appropriate associated support networks. It will be valid for 3 years, and school-aged children will be able to continue their education. This support is via the subclass 786 visa, and its processing will be prioritized to assist the people of Ukraine. Let us hope and pray that the people of Ukraine will one day soon be able to live their lives without the fear of being murdered for just living in their home country. We reported last week how certain people who hold the short-term 482 visa and the 457 visa can have access to permanent residency through their same employer. The regulations surrounding the 186 Employer Nomination Scheme visa were altered to allow some applicants to have access to the transition stream. It was expected that change would suit all 482 short-term visa holders, but in the end, it turned out the strict qualifying conditions really only benefit people who were in Australia during the pandemic period for at least 12 months. You can watch a detailed explanation of this change in the video linked in the description below and at the end of this one. The recognised graduate subclass 476 visa holders who lost time in Australia as a result of the COVID-19 international border restrictions will have their visas extended for 24 months. This visa allows recent engineering graduates to live, work or study in Australia. This will provide eligible visa holders with the usual length of the visa plus an additional 6 months. There are several thousand skilled recognised graduate visa holders who lost time in Australia due to the travel restrictions. The extension is expected to take effect in April. It will also apply to people whose visas have already expired, providing they were unable to use the full length of their original visa due to the COVID-19 international travel restrictions. Stay tuned next month when we'll bring you more details of these changes. Most of you will have heard from our news reports of the welcome extensions and in many cases enlivenments of people's 485, 489 and 491 visas that took place in February. Well, for most, this enlivenment has been a positive outcome, but for dozens of families, the consequences have been quite devastating. Many visa applicants who have already applied for the permanent residence 887 visas and their old 489 visas had already expired were on their bridging visas with permission to work wherever they liked. However, they suddenly found themselves with their old 489 visas granted again. This had a dramatic effect on nullifying the BVAs and forcing them back onto the 489 conditions with the unwanted conditions attached. Today we speak to MD Shafiqul Alam, one of these families adversely affected by this automatic enlivenment process. Shafiqul, thanks for coming on the program today, and tell us, how did you feel when you first learned your visa had been brought back to life?
All in a sudden, it gave me a feel of uncertainty, panic, and instant a violator of the visa, while before the extension I was a very perfect applicant. There is no any problem, and definitely instantly it gives me a sense of being homeless and jobless because it related to my employer. At the same time, when the extension happened, I'm in metropolitan area, so I have to go out and I don't know actually what is waiting for me. I can be fired from my employer as well, because they will not be willing to hire me or keep me hiring actually while they come to know, okay, I'm not eligible to work in a metropolitan area anymore.
So after this happened, did you contact the immigration department?
Immediately, I contacted immigration department twice. So I can remember when I came to know about the extension, it was on Friday, 18 or 19 last month. Then on Monday, I called them and they come to know my situation. But these guys actually just answered the very generic answer. For me, actually, they can't give me any solution. And they hold me over the phone for 1 hour or so and took to the supervisor, and nobody could give me any solution.
Did they instruct you to abide by the conditions of your visa, being that you cannot live or work in Melbourne, your new home?
And still they can't actually give me any solution. Told me to talk these things Mara agent like you, and or otherwise I can bring this issue to AAT. I don't know actually what AAT means. And that's how actually they responded to me. They said that blatantly, as I have to abide by my active visa condition, that means actually I have to follow my active visa condition, which is extended for 8-9, but I have to move out. So, and financially also it's costing me. Beside the mental thing, financially it's costing me, and I just estimated it's $3,000 already. I estimated that is costing me for moving out from the metropolitan to regional area. Yep.
These have been devastating circumstances. How did you feel about what the department has done to you?
It is one sense unjustified, and it's something very unjustified and very wrong, very unfair, if I would say. And it is very blatant. If we can just have a look, their explanatory note of the amendment. They're saying that in page 2 of the explanatory note, paragraph 7, they're saying that the amendments are beneficial to affected visa holders and do not disadvantage other people. You see, they're saying this in their explanatory note. Okay, there is page 13 in the explanatory note, paragraph 1. They're saying that there is no disadvantageous impact on any person's right or liability are imposed or any person in respect of anything done or omitted to be done before the instruments is registered.
Thanks, Shafiqul. We appreciate the bravery you've shown to speak out publicly about this, and thanks for coming on the show today. Yes, it does say in the explanatory statements that no one was to be adversely affected by the visa enlivenments, but clearly this was not true. It should have been completely obvious that many who have already lodged their 887 permanent residency applications do not need their visas granted again, and to do this without their permission was a gross violation of their human rights. The fact that the department has done nothing for these people, despite being a month after becoming aware of their circumstances, demonstrates an intolerable callousness of the minister's office. We have brought this to the attention of the minister ourselves, and we're still waiting for a response. Our full interview with Shafiqul will be up shortly on our channel, and when it is up you will find a link at the end of this video and in the description below, so make sure you check out the full details. On the 16th of March, the government expanded the 408 pandemic visa by removing the limitation to work only in certain sectors. This new provision will support businesses across Australia to recover from the COVID-19 pandemic. The visa allows applicants to remain in Australia for up to 12 additional months if working in or intending to work in a key sector. Now, these key sectors are agriculture, food processing, healthcare, aged care, disability care, childcare, and tourism and hospitality. You will be granted a 6-month visa for working or intending to work in any other sector. It effectively removes the problematic issue that the original pandemic visa was designed for people who could not leave Australia. Now it has become a visa asking people to stay and work and continue to support this country. The COVID-19 pandemic visa has become the cheap and most economical way the government can keep skilled workers within Australia by providing them a visa which is free of charge so they can work in any business sector within the Australian community. While the skills shortages still exist, we expect that the COVID pandemic 408 visa will probably remain available to applicants for the rest of this year. On the 5th of March, laws were changed allowing the Hong Kong regional stream on the 191 visa to open to applications. The other streams of the 191 visa will not come into effect until November this year, where it will be open to those holding the 491 and 494 visas. On the 6th of March, the Immigration Department passed new laws called the Pacific Australia Labour Mobility Regulations. This change effectively removed the old seasonal worker program and the Pacific labour streams from the 403 visa. This new Pacific Australia Mobility Stream, known as the PALM Stream, provides for the entry of temporary stay workers from countries which Australia has agreements across the range of sectors, and there are identified market gaps and workforce needs. Now, these sectors are, but are not limited to, horticultural, meat processing, dairy, wool grains, fisheries, forestry, hospitality, and aged care. This is a significant change from the seasonal workers programs, which were predominantly agricultural sector focused. Perhaps the most significant of all is the opening up of the aged care sector. This will no doubt attract many female workers from the Pacific Islands, where the old streams were predominantly focused on male agricultural labour. Currently, the Australian government is still working on which countries will be authorised to participate in this stream. We expect the announcement will come in the next following month, probably before the election. Paper-based applications are now officially deceased for the Visitor 600 visa. On the 4th of March, the Immigration Department moved to an online-only application platform to bring this visa in line with most other Australian visas. This will enhance the visa processing times, where these applications may be processed from any varied processing centres the department has within Australia or even overseas. The requirements for the Visitor 600 visa is essentially the same and has not changed. Changes to the laws regarding student visas now allow visa holders and their dependents to work full-time before the course of study in Australia commences. This will be where they held a substantive visa or a bridging visa that permitted them to work in Australia at the time they apply for the student visa. This change will enable temporary visa holders working in Australia to continue working on the student visa before their studies commenced, which helps alleviate the pressure on industries due to the impact of the pandemic. As I said, this has been a busy month, so thank you for staying with us to catch up with all the latest news. The upcoming federal budget is expected to be a major benefit to those looking to migrate to Australia, so stay tuned for our special edition later this week. Don't forget to subscribe to this channel so you don't miss it. As always, take care out there, and I'll see you next time. So bye for now.